Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. I've been asked to give some opinions, some commentary regarding defense expert Cy Ray with respect to a book that he recently published and an interview that he gave on the Custody Queens podcast, where, in my opinion, he seemed to sound more like a member of the state's team than the defense's team. He appeared to come across and say he felt that Mr. Kohberger was guilty of the crimes that occurred at 1122 King Road. And the question that I have in my mind is, if that was the case, why, number one, would he ever agree to testify as an expert on behalf of the defense? This was, as Mr. Ray has said, the only time in his career as a former law enforcement official who retired and then became an expert witness had ever testified for a defendant. This was the first time he would be testifying as a defense expert. And in fact, he did appear at a hearing before Judge John Judge to testify on behalf of the defense. He also did something that no other expert on either side did before the gag order was lifted, as it was in July of 2025 after change of plea. And he gave an interview at CrimeCon, albeit he didn't speak about the case. But this interview happened shortly after, within 48 hours or so after his testimony before Judge Judge. But what is puzzling me most of all is not just if he felt Mr. Kohberger committed the crimes, why would he ever agree to be his expert witness? And more importantly, why would he ever be part of Mr. Kohberger's alibi defense? Mr. Ray was not just offered up as a CSLI expert who was anticipated to testify that during the time that these crimes occurred, Mr. Kohberger could not have done them because he was somewhere else, and to use technology to track his whereabouts. He was also a central figure of what I had referred to as a doomed alibi defense. I didn't understand why it was ever raised. Mr. Kohberger was constitutionally entitled to remain silent and never say a word, either directly or have someone else testify as to, for example, his whereabouts at the time of the crimes, as Mr. Ray was expected to do. The defense offered up alibi, but did something that, in my opinion, and I'm purely giving an opinion here, did not seem to make sense under the statute. It seemed as though some direct evidence was required. Either someone could get up on the stand and testify that they saw Mr. Kohberger and had personal knowledge that he was elsewhere. An example that I gave was perhaps a supervisor testifying at trial that a defendant is working at the time. They know that because they interacted with the defendant. There's maybe video of the defendant at the workplace. Here's timesheets. Here's pay for that time in question. But that's not what Mr. Ray was going to do. He was going to testify that Mr. Kohberger was at a park in Washington, far from the crime scene, Way Park, that he had a habit and he enjoyed going out for drives. In my opinion, that was very helpful for the state. He's now admitting that he wasn't at home, for example, but he was out driving. And in trying to research other cases, I could not come up with a situation like this, where someone that didn't have firsthand knowledge was testifying as to alibi. And the state was very clear. They said, if Mr. Kohberger is going to continue to insist on this alibi defense, he needs to get up on the stand. We want to be able to bring this defense in through alibi, and it would be Mr. Ray who was going to testify. It was confusing to me at the time. I criticized the defense. I also criticized Mr. Ray, and I got some backlash for that because in a lot of people's opinions back then, they were completely won over by Mr. Ray based on, for example, the testimony that he gave in Latah County. But I stood firm. It didn't make sense to me. The judge denied it. And also, Mr. Ray seemed to make some very strong opinions and legal opinions that this was exculpatory, that was exculpatory. That's a question, in my opinion, that the judge was to make, not an expert witness. And whether or not Mr. Ray's testimony would be believed is just like any other witness. That would have been up to the jury if there had been a trial to put whatever weight that they felt on any expert's testimony. But bottom line, if Mr. Ray feels that Mr. Kohberger is guilty, why would he ever agree to play any role in his alibi defense? That's a question that remains unanswered, in my opinion, and my opinion only. Until next time, this is Kathy. Thank you for joining us here today.